Hello friends, I'm Rhythm. Me and my group members will select the case Koehler versus Cerebos for the group assignment. Now we are going to present the video.
Hi, this is Muskan Singla and I will be giving the introduction of this case. The phenomena of work stress induced psychiatric illness claims in the 1990s has continued apace in the new millennium. Stress related disability have been virtually removed from the workers' compensation legislation applicable in the state of Western Australia, and this has facilitated common law claims for work stress related psychiatric illness. The facts in this case are not very complicated. The employee was originally employed as a full time worker before being retrenched by the employer. Upon retrenchment, she accepted an offer from the employer to reappoint her on part-time basis. During the course of her part-time employment, she complained to the management on many occasions about the workload. As the employer could have easily provided the employee with assistance without much difficulty or expense but failed to do so, the judgment was given in the favor of employee. However, on appeal, the full court of Supreme Court of Western Australia overturned the commissioner's decision. The full court decided that the employer could not have reasonably foreseen the employee's psychiatric illness arising from the workload. Two important issues were explored in the decision. First, with regard to the nature of reasonable forcibility and the vulnerabilities of employees in the workplace stress induced psychiatric illness cases. And secondly, in relation to the more controversial issue of the impact of the employment contractual framework in determining the duty of care. Now, further, my friend would continue about the legal issues in this case. Thank you.
Hi, my name is Gagandeep Karandava and my student ID is AC8392. I will be trying some legal issues of the case. The applicant was working 3 days in a week as a retailer for the employer. For her satisfaction to be fulfilled, she could not perform her duties given to her and expected from her. She continually keeps asking to the management of her business that some changes must be made to her given job. She always asks them to make some changes in the work that is expected from her or need to have some more time to complete that or need someone's help to complete with that. But no changes were made to it. Subsequently, 5 months to the beginning of this work, she felt sick. Initially, the physical issue was suspected, but later on, medical conditions told that she is suffering from mental sickness. Her work was the reason for that. In the District Court of Western Australia, Commissioner Graves found that the appealing party workload was extreme, that the employer required no specific ability to predict that there was a risk of injury to the applicant of that kind that ensured, and that by not expanding the applicant's hours of working or giving her any sort of help, the employer failed in its obligation to guarantee that every single sensible stride was given to the applicant a protective arrangement of work. On a request to the full court of the Supreme Court of Western Australia, the court held that the business employer could not sensibly had predicted the plaintiff was exposed to danger of mental damage because of her obligations at work. That being thus, the business employer's appeal was permitted. The litigant now claims to this court. The full court was correct. The appeal ought to be rejected. Thank you. And now Rhythm is going to talk about background and facts of the case. Thank you.
Rhythm here. I'm going to talk about the background facts of the case and the argument of the case. Before starting the job as a part-time merchandising representative, the plaintiff was employed full-time by the company employer as a business agent. She worked in that position between November 1994 and April 1996 as a business agent. The plaintiff worked in independent market when the business lost privilege to circulate a critical scope of items. She got offered to re-engagement as a part-time merchandising from 29 April 1996, and she accepted that offer, which was all about the basic frame of her agreement of working, including beginning date, working days, and pay. First day of the job, she came to know that territory listing and stores and found it difficult And at once she said that there was no chance that she could do this in 24 hours. She been told by her supervisor to take a drive for at least for a month, and if still she felt that she is not able to do that, she can let him know. Argument of the case. Joint judgment created a bit of the importance to the offended party to consist to play out the allotted duties and given duties was in the position of an conflict that plaintiff should have understand the performance of the given task represented a hazard of the offended party's mental being, which is because of her agreement to attempt the work revealed a readiness to attempt as well as conflicting with her engaging a threat of her well-being. Now Hung is going to talk about the judgment of the court. Thank you.
Hi, my name is Hồng Ngọc Bùi. My student number is STN8020. Today I'm talking about the judgment of the court. As the care of duty that there is not any mental harm to the employee and the employer. They cannot accurately predict that the plaintiff will suffer mental harm due to working. The court had given two reasons. One, plaintiff agreed to perform the task through a contract she had made. Therefore, the plaintiff cannot have any evidence to accuse the defendant caused her battery if she did not agree to sign the contract. 2. The defendant did not have any reason to suspect the plaintiff because all complaints related to work without maintaining her health. In the context of mental illness that causes stress in the workplace, the Supreme Court has determined that this concept of predictability must be a based on signs and symptoms of a mental illness of the employee, which is particularly clear to the employer. B. The explanation is based on the contract magic, as we have seen in Koehler, the employer's priority. And after that, Papisha is talking about critical analysis of why the court decided in favor of Cerebos.
Hello everyone, my name is Pavitra and I'm here to do a quick video presentation on my part of this assignment. In this assignment, my part is critical analysis of why the court decided in favor of Cerebos. In this case, it is very clear that the court has made decision in favor of Cerebos by stating that they are not guilty of causing Miss Koehler's psychiatric injury, but on the other hand, Miss Koehler was claiming that she has got this psychiatric injury due to her overload in the work while working with Cerebos. Well, during her part-time employment with the Cerebos, Miss Koehler was required to carry and lift heavy boxes of goods, and which has created problems and aches in her body. So she went to see a doctor, and the doctor has diagnosed her with fibromyalgia syndrome, which is a psychological disorder that is caused due to her work overload. So here in this case, the court should have considered the mental illness that suffered by the Koehlers and the risks of her working environment. any employer should not have allowed or permitted to let the employee to work beyond the work limitation, so that in